Excellent. So welcome to the question time with the Party Wal guy. We're actually doing a Facebook Live alongside our normal Zoom, so trying it out for today. Great. So thank you for coming with, thank you for being with us. Just a quick housekeeping. It's a Zoom webinar, not slightly different to Zoom call. In case there's a fire alarm, my exit's over there. I can't help you with your exit, but I'm sure you're aware where your exit is. This will only be half an hour, so no need for refreshments and bathrooms and etc. There are phone. If you're viewing this from the phone, these are the phone options. And I'm gonna. Where's my? Sorry, I'm just trying to get my the pointer with me, so no, can't work it out there. Sorry. So if you're viewing it from the phone, you'll have your mic option and your hands up and your questions. So please put your questions as you think of them. And if you get an incoming call, this will disrupt your audio. Just put that once you disconnect, you might have to rejoin the webinar, get your audio back. Please keep it on mute unless you want to ask a question, and then when we'll come to it, we'll do that. If I lose internet connection, we've got a backup. It'll take a minute for us to get there. And if you lose Wi-Fi connection, Zoom usually reconnects itself. These recordings will end up on YouTube 1996. This is our channel, 1996 Party Wal. They'll get edited and eventually end up on there. Also, we're going to find a way of distributing the PDF, but if you'd like one, send me an email or link with me on my LinkedIn connection. Here's my book. Hold off on buying it just yet. It's being revised currently, and we're looking to bring an audio version out as well. And question and answer again. Put your hands up if you've got a question. I'll come to you. And also put your question in the chat box. I'm just monitoring the chat box on this side. So, question. I've had a question this week, really interesting, and this I guess follows on from one I had a week or so ago. Someone rang me up, bought a flat, and I want to do a rear extension. Do I need a Party Wal agreement? And the question was a bit more specific because these guys had started the process, but I'm just going to slightly edit the question. Do I need a Party Wal agreement with the flat above, with the freeholder of my building, and the neighbour? So these guys are looking to do a rear extension. And just a quick background on the issues involved, very similar to the airspace answer, slightly different here though. So if it's within your building, you'll need freeholder's consent. And that depends if you own a part of the freeholder, part of the freehold. So leaseholders sometimes have a share of the freehold. So make sure you've got freeholder's consent before you do any sort of works. Within that freeholder's consent, it's better to wrap up the scaffolding license in there so you don't have to end up paying extra costs and cause delays. And also, you should try and wrap up your Party Wal consent with your freeholder's consent, in that it will save you time and money. So please make sure you do that. And occasionally the freeholders will say, no, Party Wal is a separate process. And depending on their view, you can't convince them. So sometimes you end up having to do the Party Wal process anyway. Okay. So there might be Party Wal issues and the Party Wal issues with the adjoining owners. So this is the major question I'd really like to address. I'm just trying to find my pointing thing, so just stay with me for a minute. No, managed to cut you off, sorry guys. No, don't want to do that one. I can't find my pointy thing. It must be something to do with his face. Right, so I'm just going to talk you through it. So section 6, when you're doing a rear extension of anything, of any building, first thing that comes into play is section 6 notices for rear extension. You can get section 1 as well, and we'll talk about section 1 separately. Section 6 is actually a notice for excavation. So here's a rough representation of the buildings involved. So in this question, after a discussion, the chap who bought the flat was in the middle of a terrace. His was the ground floor. So ground floor are green in this occasion. So he's got the middle terrace flat on the ground floor. And in this building, they've got 3 flats, very similar on both sides. So, and they need to serve section 6 notices. Their flat is the ground floor flat in between in a terrace. So they've got 2 surrounding neighbors. So first question, who do they serve a section 6 notice to? So as we're viewing it, it'll be the freeholders on the left and the leaseholders adjoining their flat. Now, because they're on the ground floor, these guys are actually basement and ground floor, but all the neighboring flats are configured in the same way. So on this occasion, it'll be the same flat on the left, as well as the freeholder, and on the right, it'll be the right-hand side freeholder and the leaseholder on the right-hand side. So just to run through a section 6 notice in case you've missed my plethora of YouTube videos and all the trainings I do. So just to go through it again. Section 6.1 notice requires, it's a 2-part test. So the first part is if you're excavating within 3 meters of any part of an adjoining owner's building, and so it's 2 parts. So it's an and, it's not either or. And to a lower level of the bottom of their foundations. And I repeat, it's any part of their structure, not just, well, we only touch on it slightly, so it doesn't include it. So beware of that point, important here. Any part. So let me talk you through a section. And here it is condensed. So within 3 meters and lower level. So I'm going to use this as an illustration, but it applies equally well to that flat scenario. We've got, usually when you've got foundations, they usually project slightly beyond the wall. So when you're measuring and the distance is right to the edge, you need to allow for that nib. So if in doubt, serve a notice. So if it's within 3 meters, and if you've got a terrace property, they're 2 together, so that's obviously going to be within 3 meters. And if it's to a horizontal lower level, so lower horizontal level from their foundation. Now, in this scenario, you're going to get a couple of questions. How do we know what the neighbor's foundations are? And for this, the interesting way of looking at it is, you have to estimate the year of their building. So usually if things are built below 1976, they'll have a very shallow foundation. If they're post 76/80s, because there was quite a significant heat wave in 1976, building regulations changed. And that's why we have the new building regulations where they ask you to be meter 1.2, between 1 meter and 1.2. So, and therefore buildings built after that have a deeper foundation. You still can get new buildings built after that. They're still notifiable. It could be the slope of the road. It could be because you've got trees, you're going to have to go deeper, or you're doing piling. So various issues. That's not the only test. That's one way of looking at it. Buildings before 1976. The second way to look at it is you could do a trial hole in your own building, and if the neighbor ones look similar, roughly speaking, your foundations are going to be similar. And the third point is, if in doubt, you should notify. So that's the general presumption that we go on. Now, the section 6.1, there's a more interesting section 6.2 and slightly more complex. So I'm going to go through this again as well, because you could have the case that you're not doing trench foundations, you're doing what's called piling foundations, and they're a lot deeper, or you're creating a basement in terms of your terrace, and then you have to look at another test. So I'm going to go through section 6.2 for you in this scenario. So if it's within a 6 meter distance measured horizontally, and any part of it forms a 90-degree when measured horizontally from the line intersecting on the plane. Yeah, that's quite interesting. I'm not going to read it out to you word for word, but there is a really good illustration. It's in the government booklet as well, and that's where I borrowed this schematic from. So there's your 6 meter thing. So again, 2-part test, 6 meters. And what we're looking at here is if where you're excavating from, you should be able to see it, the 45 degrees is actually here, there. So that's the bottom of your foundation, edge of it, to the corner of their foundation. And if that forms a 45 degrees angle, and that building's within 6 meters, they're also notifiable under section 6.2. So that's another one to bear in mind, because sometimes if this was a flat on the right hand side, we're excavating deeper to form a basement, we may have to notify owners within 6 meters. That's a 6.2 test. Just going back to that scenario where we had, let's go back to that one, where we had these guys doing a flat, both the owners are notifiable. In this scenario, they'd actually drafted the notices themselves, posted it out to the neighbours quite some time ago, and no reply. So this takes us into a different part of the Act. What do you do if there's no reply to your Party Wal notice? So I'm going to go through that bit now. Just run through some of that's the previous bit I've been through before. So I'm going to go through some of the basic outline of the Party Wal Act and the process for it. So this is where we get into the 10.4 process. Now, this is defined under section 10.4. That's why we refer to it as the 10.4 process. So step 1 is you give your neighbours, work out the notifiable owners, give them a notice, and section 6 is one of those sections which, if you receive no response, it's a deemed dissent. Now, let me repeat that, deemed dissent, which means that it's assumed that the neighbours have dissented. You can't give them a notice and then just say, never heard anything, carry on. So that's wrong. It's a deemed dissent, and the reason we've put 14 plus 2 days, 2 days is to allow for the postage. Now, it's a really good thing, and it's recommended that you also say to your neighbours, you hand deliver notices, have a chat with them if you can, and be friendly. But you have to bear in mind that they may not respond, or not all the neighbours may respond, because look, stuff's busy at the moment. There's other important issues going on, which I'm not going to go into now, and neighbours may not have the time to respond. But you don't want to be, and it's not a case of 1 or 2 days, it could be months before they respond, and they generally tend to forget about these things. So what you don't want to do is give them a notice and then not know what you're doing next. And this is where the government booklet's slightly weak on this issue. What you should do in parallel is post a notice. But when you go to the post office, you need to get a certificate of posting. Not recorded delivery, not a special delivery, nothing else. And I was having a chat with the post office chat this morning. You wanted special delivery. I think we were having a bit of a joke, actually, because I've explained it to him. So the plus 2 days is to allow is for the Deemed Service Act to kick in place. So what's happening is the 2 days means it's deemed to be served. Now, it doesn't matter whether they get it, it's lost in the post, or the dog eats it when the postman's trying to deliver it. It's all irrelevant. If you've got a certificate of posting, assume that within 2 days, they're going to receive that the notice has been served. 14 days later, they've not responded. They're in automatic dissent. Now, this is when you send, and in the Party Wal surveyors world, we call it a 10.4 letter. you send them a letter reminding them, look, we've sent you a notice, it was dated this date, we haven't received a reply, you're in dissent, you've still got the options of consent or consent with a schedule of condition and consenting for, you've still got your options available if you choose, but however, at this point, you're in dissent. And if you don't reply to us within 10 days, we'll appoint a surveyor on your behalf. So essentially what we're saying under the 10-4 process is you can't start works without with no response, and you have to follow this process. Now, at this point, you're sending a letter that gives them 10 days. Again, it's the 2 days for service. So deemed service act, 2 days, certificate of posting, not recorded delivery. Send them another letter. It's a different letter to the original notice. You can, if you want, put a copy of the notices, but you need to be aware that it needs to be a reminder letter under 10, and it quote the section number. So therefore, at stage 2, you give them another 12 days. Running totals up to 28 days on this scenario. And after the 28 days passes, you have to appoint a surveyor on their behalf. Now, you can't use the same surveyor as yourself. Can't be an agreed surveyor. And you can't not do anything and just continue with the works. You have to appoint a surveyor on their behalf. Now, at stage 3 on this scenario, we're at 30 days, 38 days, just past that. If a surveyor is appointed on their behalf, they can't be unappointed. So the adjoining owner can't come in and say, I don't like this chap, I'm going to appoint my own, you didn't do X, Y, Z, because you've got the documentation. You've got the certificate of posting for the notice, you've got the certificate of posting for the 10-4 letter, you've appointed a surveyor on behalf, and this needs to be done in writing, and it's done by the building owners. So it's literally moving the process on, so you're not having to wait forever and a day to hear from the neighbours. And some adjoining owners don't like the works that are being proposed next door and think that they can frustrate the process by not responding to notices. It can't be done. That's wrong. Well, it can't be done unless you fail to follow the 10-4 process. So once the surveyor appointed on their behalf, the adjoining owner surveyor writes to the folks next door, and I've put in there 10 days, but it could be any number of days that they give them. Awards then served. Now, in their letter for letting them know that they've been appointed, they'll usually ask for access. We're just in the middle of a project where access was easier available. I'm going to go into that one later. Really interesting scenario where the building owner isn't going to be paying all the costs. So that's a different subject. That's to become sort of doing a little trailer on that one. So in this scenario where we're doing a rear extension, all the costs will go to the building owner. However, at stage 4, there's an award agreed between the 2 owners. It's ideal to get access and do a schedule of condition. If it's not available, there's nothing we can do about it. So that's the 10-4 process. Now you're thinking, do I really need to do this? It's just going to add extra expense. What if I don't do it? And I didn't know about this. So you do know about it because I've just told you, but even if you didn't know about it, you should get advice. Ignorance of the law doesn't count. So not knowing about it doesn't help you. So you need to understand this. And the Party Wal Act is one of these strict rules that regardless of whether you know about it or not, the law believes that you should have known about it. Therefore, it's deemed that you do know about it, and defense saying I didn't know about this doesn't help you. Okay, so if you don't carry out the 10-4 process, what could be the result? The result could be that there's no survey of the adjoining owner's property. So if you're the adjoining owner, if there's no survey of your property, it makes it difficult for you to make a claim, and you're better off engaging in the process. And Party Wal surveyors under our duty to act fairly and impartially and not take sides, regardless of who and how they're appointed. So make sure you engage if you're an adjoining owner and you've come to this part of the process. On the other side, if you're the building owner and you don't carry out the 10-4 process, what may happen is when they see the scaffolding up, or when they see the builders turning up, or when the builders start digging away, or even they hear noise and so forth, or it may be that they've been on a holiday, they've just got back, they've been under quarantine abroad or whatever. They've just got back and they're saying, hang on a minute, what's going on here? This building works. Where's my Party Wal notice? And the other reason they'll get hyped up, I'll go into in a minute. They probably received a stack of letters from other surveyors saying, oh, there's works next door, XYZ, appoint us, blah, blah, blah. So that's the other reason for making sure you carry this process out. And literally it's a case of closing the door and getting on with it. Now, as a building owner, your works could end up being stopped while the adjoining owner appoints a surveyor and goes through it. It's not a good thing to be getting involved in. We've had this in the past, so don't make sure you carry out the 10-4 process. I think that's, happy to discuss that if you'd like to discuss that. So going back a step or two, why take the Party Wal process? This is important, and make sure you carry it out to 10-4 as well. So schedule of condition. Now this is a photographic survey of the adjoining owner's property. It protects you from getting false and malicious claims. Now we have been on a number of surveys. In fact, I might do a little quiz one day. Bring on a number of photographs where it says, was this before or after? And we've looked at the damage, and it's actually before the work start. But everybody, the adjoining owner said, they've damaged my property. We've gone through the schedule of condition and found out, actually, that's not true. The damage was already there. So it avoids building owner having to face false and malicious claims. And what's generally happening is the owners next door hear all this racket, hear all this noise, hear all this drilling and so forth, normal construction stuff. And they start looking and saying, where does this crack come from? This wasn't there before. I've even had an occasion where I've gone and done a survey, and this isn't being sexist. The chap wasn't home. His wife was at home. I said, have you had any leaks? She said, yeah, we had a bathroom leak above the passage. There's the watermark. Took a photo, logged it in my survey, sent him the survey, and this chap phones me up. He was quite upset and said, there's no watermark in my house. Where's this come from? This schedule's wrong. I'm sitting there thinking, And he said it so in such a certain way. He was so certain there's no damage. I thought, maybe I've mixed the photos up. So had a look at the photos, had a look at the files, got the photo. And I was so sure that, I can't get this wrong. I had a conversation there. Anyway, so I took the photograph out, sent it to him, and actually didn't hear any more back. So it just we all go through, we're all in a routine. We get a bit oblivious to things that are around us. And then suddenly when neighbors are working at it, that's how we get some, we're looking at things closer, and then we end up noticing stuff that was already there. So it's there to protect building owner from false and malicious claims. Now, the other thing, as I just mentioned, is your works may end up being stopped midstream. So, they're going to do a loft conversion. They've ripped the roof off. They're about to start works. Neighbor says, where's my Party Wal agreement? But we haven't done it. We didn't ask for one. We didn't know about the 10-4 process. Nobody told us. We didn't know we had to do a Party Wal agreement. All the rest of it, all the stuff I hear on a daily basis, basically. So your works get stopped midstream, and we're in the summer now, and we've had a few days of quite heavy rainfall. You don't really want that going on when you've got no roof on your building, or even worse, when your builders are on site and saying, we've had to stop works, it's your fault. There's delay charges for us not being able to carry on works. Now, the next point here is it's your responsibility as a building owner. It's not the architect's job. It's not the project manager's job. It's not the builder's job. It's your responsibility. You can delegate it out, but in the end, it's the owner's strict responsibility as a property owner. So that's one of the responsibilities, the joys, if you like, of owning property. And especially where you're doing an extension. So everybody likes nice, new, shiny extensions, and but nobody really likes the process, I'm guessing, unless you're a builder or a developer. So very few people like the process. But just to reiterate, it's your responsibility as a building owner to make sure this is done. Now, you could get the scenario where you don't do it and you tell the neighbor to go where, you know, in so many words, you tell him to disappear. He may go and see a friendly solicitor who will say, yeah, look, you should have done a party wall notice. He hasn't done it. Let's take some legal action for you. And that'll involve legal costs for everybody, which isn't great. So please don't get yourself into that position. It is avoidable. You do have to have patience, and you should start as early as possible. I'm going to go into that bit in a minute. And finally, it's the law, and anything with the law saying I didn't know about it is no good. It's not a defense. Just a quick run through the basic terms. You have the building owner, so that'll in that scenario, there's those chaps, that chap that's bought that flat. On the other side, you've got adjoining owners. Now you could have multiple classes. So freeholders. So there's one freeholder on each side in that scenario. There's also leaseholders in this scenario. So the lower ground and basement flat, there's leaseholder on each side. And it could be the case that these guys, the flats are configured differently. So they're doing works on ground and first floor, basement and ground floor. And there's two different flats next door because they're configured. So there could be two leaseholders on each side. So it's leaseholders, but it's leaseholder of more than 1 year. And this is where you get a little gap sometimes, because you can get leaseholders of less than 7 years that aren't registered in the land registry. We can't pick those up. So therefore, leaseholders of between 1 and 7 years are also notifiable. And there we have to reissue notices. Now, you also have owners who have rights to receive profits. These are things like trusts and people who've done lease option agreements or various other things, and they have a right to receive profits. So they have an interest in that land or that property. And last but not least, if they're contracted to buy, you could get the scenario, you've given a party wall notice to the neighbor, they're saying, we don't really care because we're selling the property. And the point that it counts where you become an owner is at the point of exchange. Where they're ready to sell and contract hasn't quite exchanged, it's still good to get the adjoining owners involved. Now, on the other side, you become a building owner once you exchange on a contract. So if you're going to do some works and you've just exchanged, that's the point to start the party wall process. The groups that are excluded are short hold tenants, council tenants, and mortgage companies. So you don't need to notify those, that group. That's most of my run through today. I'm just going to see if there's any more questions. Oh, great. We've got a couple of questions here. So, excellent question. Does the building owner choose the surveyor under section 10.4, or does the building owner surveyor have to choose another surveyor to act on their behalf? Great question. It's actually the building owner who appoints the surveyor, but usually they'll ask for recommendations from the building, and you know, they'll talk to the building owner surveyor. So that they've got a relationship with us that say, look, who do you recommend we appoint? And we'll say, well, point X, Y, Z. It's your choice. Legally speaking, it's the building owner that appoints the surveyor, unless the building owner surveyor it has the right to appoint a surveyor. Either way, it's the same thing. So you shouldn't have that issue, but it can't be the same as the building owner surveyor. Thank you for that question. Really great. Another question. Excellent. Does section 6 notice, not section 1, qualify someone to submit a section 8 form and to be able to gain access to the adjoining neighbor's land? Interesting. So a section 6 notice is for digging a trench. So you may or will need to put hoarding on their land to protect it, but you don't get access to their land. You could do, if you could argue that, sorry, lamp's going off. You could do it if you're arguing that you need access and able to carry out the works. So if you're doing section 6 note, it's very unusual to get access to land, neighboring owners' land when you're just doing section 6 works. It's you, and it all section 6 is doing usually a strip foundation. Now, Where you've got piles and you need the machinery to operate, you can argue that we need access to your land because we're going to drive the piles through, the machinery needs to rest. And because it's in pursuance of the Act, yes, you can get access, but it's only for doing the piles. It's not for building the wall. So the answer is, yes, you can get access to adjoining owners' land for Section 6, but again, it's only dependent upon that digging of those foundations. So any works in pursuance of the Act gives you rights for access to the adjoining owner's land, subject to it being notifiable. Got another question. Excellent. We're doing well today. Thanks. Brilliant. Does a Section 2.3 notice cutting in lead flashing allow you to complete a Section 8 right of access form to gain access, i.e. to be able to stand on the adjoining owner's roof to complete the works? Theoretically speaking, yes, you could stand on the roof if it's in pursuance of the Act. It's not always a good idea, but yes, you can ask for Section 8. You say, well, we need to gain access. Give me there's your Section 8 notice, and you're very specific. Just cutting into lead fleshing of the adjoining owner's land. So going back to the principle, it's anything works in pursuance of the Act. Got another question. We're doing quite well today. Right, so hopefully that's answered that one about the lead fleshing. I believe it does. You may end up having an argument with the other surveyor and then maybe consult the third surveyor, but it's usually any works in pursuance of the Act. Also, why is the emphasis so much on certificate of posting as recorded delivery does the same thing? Taken to court is proof of having used recorded delivery sufficient and will not hold up in court? Brilliant question. Thank you very much. I'm not going to name you because I'm not sure if you want to be named. Super good question. Thank you for that. Yeah, so certificate of posting comes under the Deemed Service Act. When you get a certificate of posting, it means 2 days later, it's deemed that 48 hours later, that letter has been served and it's arrived. Now, on the recorded delivery, you could get the scenario where the guy, postman knocks, nobody answers the door, the sticker little red slip in, and then people turn up home and say, sounds trouble, I'm not going to bother going to sign up. Or they might not get the time, they might not be able to do it. So recorded delivery isn't deemed service because until someone signed for it and gone and collected the letter, it hasn't been served on that person. And also, minor point, I mean, it's literally pennies. Certificate of posting is cheaper than recorded delivery. So does that make, I know it's counterintuitive and I get the same question each time. Literally, and now they're doing it just for fun, I'm sure. Do you want a recorded delivery or do you want special delivery? You know, when you ask for a certificate of posting, you think, important documents, you must want it special delivery or recorded delivery. No. Certificate of posting, that's the way to do it. So it is counterintuitive and it goes against what you're thinking, but if it ends up in court, it isn't regarded as being delivered because, like I said, they could not sign for it. I'm just going to check to see if there's any more questions. Got another question. Re-letter of appointment or will a signed dated consent form suffice? After serving a notice on the adjoining owner, the owner sends back a signed and dated consent form confirming they would like to appoint me to act on their behalf as agreed surveyor. Would it still be required to obtain a separate letter of appointment, or will the consent form suffice? So basically, thank you for that. Really good question. So a consent form is a form of letter of appointment. So, you know, if you've got it on your consent form, say, it depends on how you've worded it. We actually have separate letter of appointment and a separate slip at the bottom. So just to make sure. A consent form is just a form of letter of appointment. So the question is, if they send you back a consent, do you need a separate letter of appointment as an agreed surveyor? It all depends on how well set out your consent form is. So if it's set out in detail and it's virtually saying the same thing, then you're fine. And also, if it says as an agreed surveyor, you don't have to show it to another surveyor. So that, and those are the 2 points you need to be aware of. So it all depends on how clearly set out that is. And lots of times we see letter of appointment in the form of form. So that's fine. It's just terminology we're referring to. As long as it says, I appoint you under the Act to act as agreed surveyor or our surveyor with regards to these works, to serve and receive and make appointments. There's a couple of 3 sentences that need to go in there. As long as it's got that somewhere signed and dated and address of the property, that's sufficient. Just going to check to see if there's more questions. Hey, excellent. Got another one. What happens if the foundation design changes after the award's been served due to building control asking to dig deeper, or the foundation design changes? Does this invalidate the award? Yeah, so if you're asked to dig deeper, what happens? Usually it doesn't quite invalidate the award. It means you need to do an update on it. So if you think it's going to be, it depends what how you've worded the award. So in some awards we'll say, as per requirement of the building control officer, which you can get away with. In other cases, and this is where the other surveyors are involved, you end up having to say, well, we're going to go this deep, you know, and there's something about a 1500 mark that people get excited about. We're going to go this deep. If it's any deeper or any changes, we'll refer back to the surveyors. And it could be that you need to do a hit and miss or have some additional method statements. Generally, overall speaking, if there's any change in the conditions, you do need to do another award, because the award is specific to the works being done, and the method state, the time and manner, the time and manner in which those works are executed depends upon those notifiable works. Another question, excellent. Does this mean new notices will be served? It depends. If you're just digging deeper, it depends if the other surveyor is happy to take that on board and say, yes, new notices need to be served, or yeah, you're basically doing excavation, but you're doing it at a deeper level. So, you know, let's amend the award and go get on with it. It depends on the level of change. So you could end up having, originally starting with a section 6.1 notice where you're going, you know, all the owners within 3 meters are notifiable. And because you're having to dig deeper, then it becomes a section 6.2 and new owners become involved. So it's still excavation, but it could be that you have to serve notices to new owners. That's the other scenario it could occur. Usually when you've done a set of awards, the schedule of conditions already taken, it might be just a case of updating the awards. So it depends on the circumstances. I personally would say updating the awards is sufficient, but again, it depends on the project. Got another question. Interesting. Building astride the line of junction. If one neighbor wishes to tear down a party fence wall, build astride the line of junction, and rebuild a new wall forming part of a new extension, but the adjoining owner doesn't want the party fence wall to be touched, what are the rights of each? What rights do each have? Fantastic question. I think I might have to do a separate section on this. The short answer is, and I've done a project in this scenario, the building owner proposing to, forgetting the exact terminology is to, it's not quite tear down, it's to demolish and rebuild, I think is the wording in the Act. Yes, the building owner, each of the owners has that right, and the other owner, all they can do is appoint a surveyor And unfortunately, that surveyor ends up explaining to them they have the right to do it. So the building owner has the right to demolish that wall and rebuild it. The adjoining owner, all they can do is appoint a surveyor, protect their property, and make sure it's done to a decent, reasonable standard, and their property is protected. They can't stop them doing that. You're also going to get the interaction here of a definition of a party fence wall, and a party fence wall is a party wall outside the owner's original building, and it all depends on where the boundary runs. And a boundary dispute is a different area of law, not the Party Wal Act. So if the boundary runs at any point of that wall, and it could be even 25 mil of it, it's defined as a party wall or party fence. Hopefully that answers it. I might have to do a longer session on this one. Excellent. Another question. If a building owner is attempting to repair a chimney stack in the loft internally, which is partially collapsed, does this fall under section 22F? I thought repairs were under 22B that also apply. I'm not sure. We'll have to look up the Act, and I haven't got it with me. So it's basically a case of looking up the Act. I don't think it's 22B, but it actually doesn't matter because it's under section 22, subsection 2. And it used to be the scenario that when you serve notices, you had to get the exact letter right. And other surveyors used to get really upset. You don't actually have to get the exact letter right to serve, but you should look it up, and I might come back and look it up for you next week. So that's a great question. Thank you for that. So I'm not going to name you unless you want me to name you, but no. So it's under 22, probably not F, but I'll look it up for you and bring it to you next week. For another question, for a new build house adjacent to an existing party wall, I'm going to carry on for a bit. Let's see how we go on with these. For a new build house adjacent to an existing party wall, building owner submits a section 6 notice. If it mentions in the notice that the new building owner intends to underpin the current foundations on the party wall, does this need consent from the adjoining owners? Will they share the costs? Okay, so the only time you share costs is if a party wall structure has been dilapidated, it's come under dilapidations. So from the little outset of this question, if you're building a new house next to someone's house and you're underpinning because you need to reinforce because of your excavation works, I'm inclined to think, just from the point set out, the adjoining owner isn't a contributor to the cost because it's not due through dilapidations, and it may not be that it's not a party wall. It may be their own house, and depending on where the boundary runs. Even if it is a party wall, you're underpinning. They won't make a contribution to the costs. Unless both houses are slipping, and then it needs to be done for both houses' sake. So it all depends on if it's due. First point is if it's due to dilapidations, and secondly, underpinning's an unusual one. It usually ends up with the chimneys and so on, party structure. But it could be the case that because every it's decay and so forth, and age of the building and what's the phrase I'm trying to think of? Because of the age mainly, there might be a charge for the cost, but highly unlikely on the circumstances described here. So that was an interesting little, oh, please can you email me the answer? Well, I'll put it on next week's show actually. Sorry, the answer for 22F and 22B. Yeah, if you like to send me a little email, I'll obviously respond to that. So thank you for that question. Excellent. This is great. So thank you for all those questions. We have actually run over time today. I'm going to pick some of these up from in next week's question time. Now, I'm going to see who else is on here. So I'm going to go to one of our sponsors and see if I can bring them on board and go through them, but they've very kindly sponsored our show. So there we go. So, Mr. Ranjit Singh, how are you, sir?
I'm good, Dil. How are you?
I'm good, thank you. So, this looks.
Hello.
Sorry. Yeah, go on.
Good showing. Good question you're getting today.
Yeah, we're at a spate of them. So very interesting. Thank you very much. I'm just going to go to your slides. We've had a really good long question scenario today. So this is Mr. Ranjit. They're one of our sponsors, Property Investor News. Over to you, sir. You've got a new background. So tell us more about it.
Yes, my name is Ranjit from Property Investor News. Briefly, education is the only weapon to be successful. No matter what business you're in, property is no different. Become educated, knowledgeable, informed investor. Our publication, Property Investor News, provides you analysis, news, research on property investments. Also updates on mortgage, finance, legal matters, and much, much more. To subscribe today, we have a limited time offer, and to receive 3 free issues of Property Investor News, plus our 200th June issue for free also. So you're getting 4 issues instead of 3 from our normal offer. And you also get a free book, Before the Hammer Falls, by Jay Howard and Pure Riznik, who are UK's top auction experts. Main theme of our 200th June issue is student sector review, and much, much more there. To subscribe, just follow the instructions in the chat box. Remember, businesses don't fail. People who run the businesses do. Dig your well before you're thirsty. Just like to touch on yesterday, our June issue came out, which is the 200th issues. We've been going for 18 plus years. It's a magazine, like I mentioned, it's education, knowledge, and keeping up our readers up to date. And back to you, Dil, Party Wal guy.
Thank you very much, sir. Thank you for your support. So that's one of our sponsors.
You're welcome.
We couldn't do it without you. The other sponsor is Wren Kitchens. They couldn't be here today, but also thank you for them for their support. Got a few more questions coming in, but unfortunately I haven't got time to go through them. So if I can suggest, if you email, and I'm sorry, I'm going the wrong way actually. If you email or send them to me on LinkedIn, I'll address them. Here's my email. Here's our LinkedIn. The YouTube channel is 1996 Party Wal. I'll put it up on next week's slide. So thank you for coming in. Thank you for the excellent questions. And we'll see you same time next week. Look forward to it. Thank you very much.